6, City of Alachua and Newberry versus City of Archer et al. Counsel for appellant, Mr. Theriak.
May it please the court, my name is David Theriak with the law firm Theriak in Spain. Co-counsel Scott Walker with Foles Walker, who represent the appellant, City of Newberry, was unable to travel to Tallahassee today, so he asked me to send his best wishes. Before I begin, I want to start off by thanking the court and thanking the Appellee's counsel. As you all may recall, I had an emergency surgery on October 22nd, and you all granted my motion to reschedule oral argument, and the Appellee's counsel were extremely professional and did not object. So I just wanted to start off by saying thank you.
Glad to do it. Hope you're feeling better.
Yes, sir. Thank you.
Would you like to reserve any rebuttal time?
I would. Candidly, Your Honor, I don't think I'm going to use 20 minutes unless there's a lot of questions. So maybe I could start off with 13 and 7 and
Okay.
then not use all my 7. So if that's all right with the court.
Very good. We'll reserve 7. Thank you.
Thank you. I represent the appellants in a challenge to a charter amendment that the cities contend was deficient, and we've raised 5 grounds: that the county misrepresented the primary purpose of the charter amendment, that the county failed to provide voters with fair notice of the legal ramifications of the charter amendment, that the county failed to inform voters as to the vast scope of the county growth management area that was to be established by incorporation of an undisclosed map. The charter amendment set forth inadequate and confusing information regarding the removal of lands from the county growth management area, and that the charter amendment improperly invoked emotional or political rhetoric instead of accurately explaining the substance, purpose, and ramifications of the charter amendment. Before I get into each of those arguments, and some of them dovetail together, I want to take probably a half minute just to briefly read the title and the summary. The title stated, County Charter Amendment Establishing County Growth Management Area. And then the summary, shall the Alachua County Charter be amended effective countywide to establish a county growth management area, provide that the county's comprehensive plan and land development regulations will exclusively govern land development in the area, whether inside or outside municipal boundaries, authorize implementing ordinances, provide for removal of lands from the area, and provide that the charter and implementing ordinances shall prevail over conflicting municipal ordinances. As this court knows, one of the overarching components of a ballot title and ballot summary under section 101.161 sub 1 Florida statute is that the chief purpose has to be clearly set forth in either the title or the summary. And we respectfully submit that the chief purpose of this charter amendment was not to establish a county growth management area, but the chief purpose was to fundamentally alter the city's rights that apply when they annex property into their jurisdiction. And the primary purpose was to deprive the cities their right, their statutory right under 171, to assign a comprehensive plan, future land use map designation to annex property, and to assign a zoning under the land development code once they annex property.
Well, I mean, if that's their chief purpose, though, doesn't the ballot summary pretty clearly state exclusively govern land development in the area? Now, maybe the area needed to be defined better, but that's a different question. Govern land development in the area, whether inside or outside municipal boundaries. So, I mean, shouldn't an informed reader reading that say, okay, well, if I vote for this, Newberry's not going to be able to do whatever their ordinances are in this area henceforth?
I don't think it's reasonable to assume that a voter who 9 times out of 10 probably doesn't know much about land use or comprehensive plans and land development codes to read into that language that there is a radical change to the annexation process and rights that a municipality possessed prior to the charter amendment. There's one case that we cited in our brief, that when there is a change in the legal format, and that's what we have here, rights have been deprived. The city had the right to assign its own comp plan policies, its own zoning policies to annex property. They no longer can do that. And they're stuck with whatever the county had on its map, and they have to live with what the county said that property should be designated as. So you're going to have a municipality, now that the amendment passed, it was narrowly passed, where you're going to have in the city, the inability to assign city comprehensive plan, future land use map designation, city zoning, and they have to implement the counties.
Right, I mean, and it says exclusively governed, whether inside or outside the municipal boundaries. I mean, there's certainly plenty of policy reasons why that's a good or bad idea, but as far as clearly explaining to the voters what the purpose is, which the Supreme Court says purpose means effect, I don't know if I necessarily agree with that, but I got to, so purpose means effect. I mean, how is that not explaining the effect of it?
And I think our position is that we respectfully submit that language does not put a voter on notice of that fundamental change that will occur if the voter voted in favor of this proposed charter amendment. The word annexation is not even mentioned in either the title or the ballot summary.
But you're talking about a prospective effect that may or may not occur, correct? An annexation, we're not talking about a retroactive application of this amendment to land that's already within a municipality. We're talking about going forward. Annexation may happen, it may not, it may happen there, it may not, it may happen over there, it may not. Is that correct?
That's correct.
Council, you're proceeding under 101, 161, is that correct?
I did not hear you, sir.
101, 161 Florida statutes, that's
Yeah.
your statutory hook.
Yes, sir.
Where in the statute is there an establishment for a right of action to challenge the entire ballot measure that may or may not, passes in front of the voters, and then you want to deactivate that or void that based on a ballot summary?
I don't believe there's anything that expressly states that in 101.161 Florida statutes, but there is a line of cases from the Florida Supreme Court.
Looking at Florida constitutional amendments typically, right?
Yes.
And through advisory opinions, through a separate process that's designed specifically for petitions submitted on Article 11, Section 3, right?
That's correct.
Right. So for the purpose of local referenda, like this one, if 101.161 subsection 1 didn't exist, would the entire referendum or the entire charter amendment need to appear on the ballot? Or is there another provision in the election code that says that the ballot provision, whatever the proposed amendment is, won't appear on the ballot?
If I'm understanding your question, sir, you've got the entire charter amendment
Right.
that's not on the ballot.
Correct.
And it's just a title and then the summary. And I don't read anything in 161, or excuse me, 101.161 that says the entire text needs to be on the ballot.
Well, that's what I'm asking. So if it didn't exist, would the entire, is there another provision that provides for not putting the entire text on the ballot? Or do we look at 101.161 sub 1 as that is the upshot of the text, is you have the summary in place of a lengthy text that would otherwise have to be on the ballot and is logistically sometimes unworkable?
I agree that the language in 101.161 establishes that there's a title and a summary only.
Right.
And I believe that summary is capped at 75 words. And even as long ago as 2018 in the Dietzner versus League of Women Voters of Florida, they invalidated the Florida Supreme Court. invalidated a charter amendment because it failed to explain the true effect of the amendment. And, where we read this language by not mentioning annexation, and that the framework for what happens after annexation is fundamentally changed as a result of this charter amendment, that it didn't explain the true effect of the proposed charter
Right, and where I'm going with it, though, is I'm trying to find where's the public right established in this subsection. And if one way of reading subsection 1 is, look, it's unworkable to have an entire charter amendment in the length like we have here. It's unworkable to put that all on the ballot. So as a substitute, so that people know what they're voting for roughly, so, yes or no, but we're going to put a summary there, 75 words to save space. That strikes me as a procedural mechanism and not necessarily like a substantive right, like you have a right to have a summary of this lengthy, complicated charter amendment. And if that's, to me, there's a difference in that. And if it's not a right to have it summarized, isn't it enough to have something that identifies what the ballot measure is, fairly describes it, but it essentially is an invitation to any voter, if they want to find out the actual details of what they're voting on, they can go look at it because it's supposed to be available at every precinct.
I think it's more than that, Your Honor. From the Florida Supreme Court, the ballot, and I'm quoting, must be fair and advise the voter sufficiently, and to allow that voter to, quote unquote, intelligently cast her or his ballot. Another quote from Densner, give the voter fair notice of the decision he or she must make. A ballot title and summary cannot either fly under false colors or hide the ball as to the amendment's true effect. So I think there's more than just saying, here's a summary, let me pique your interest to go read the entire chart amendment. I think the Florida Supreme Court has indicated there's more to it than that, and that there's a level of specificity that needs to be in that summary. Arguably, you're never going to be able to do a good summary by just using the title, and you're just going to call the name of the charter amendment. But those 75 words are important, and here, those 75 words don't mention annexation. So that's one of our primary arguments, is that the charter amendment did not describe in the ballot summary the chief purpose, which was to fundamentally alter the city's rights after annexation.
So on that front, it sounds like you're arguing maybe that the way that this is framed, maybe it's not an appropriate provision to put in the charter, or that it was too much to try all at once to put in a charter. And with that, if you can answer this question, so the Alachua Charter makes a distinction between amendments and revisions, which is actually that distinction is lifted from Article 11, where it makes the same distinction. Amendments are discrete changes to one area of the text, and revisions are broader scale changes in operations of government, that kind of thing. This is labeled, it came from the CRC, labeled as an amendment. The summary refers to as an amendment. And then you have this long list of many things that it does, including shifting power from, and superseding effect of, so suddenly municipal ordinances are superseded by the county and that kind of thing. Is that part of your argument, that the charter, the proposed charter amendment is doing too much all at once, and that the summary doesn't capture the full weight of what's being changed with the shifting of power and that kind of thing?
I think it's a great argument that I wish I had made, Your Honor, but we did not make that in our brief, so I can't say that we made that argument, but I think your description of too much is apropos.
I mean, this seems to be happening quite a bit. It certainly happens at the state level, trying to change the Constitution by, throwing in policy and rearranging the powers of the different branches and that kind of thing, and trying to do it all at once and just put it in Article 10, for instance. And perhaps, I don't know, this sounds a lot like you're adding a ton of policy to the charter, and maybe flying under the summary just said we're just creating a growth management area or something like that.
And I only got about 46 seconds before my initial time. And that's the other part that we raised, that this phrase, county growth management area, really is not just an area. It's virtually almost all of the unincorporated land in the county. And we contend that that misled a voter. A voter had no way of knowing the scope of what this charter amendment would address. And the use of the phrase growth management, we contend is emotional. There's nothing in this charter amendment that manages growth. There's no criteria. What this amendment really does is who gets to have the power to control.
Well, I mean, isn't that growth management, though, that the county now, any of their zoning laws, any of those things are now going to govern so they can manage growth either by allowing it or restricting it pursuant to whatever powers they can use under the charter.
And that's in part also misleading, because the portion that's in the unincorporated area today, the county suggests that they need to make this area a growth management area so that the county comp plan, the county regs apply. Well, they already apply to the vast majority of what's on the map, because the unincorporated area is already regulated by the county's comprehensive plan and the county's land development code. It's only once something is annexed. And I'm into my rebuttal time. Thank you.
Thank you. Branson.
May it please the court. Corbin Hanson, representing Alachua County. Before I get into my argument, I do want to take an opportunity to discuss the revision versus amendment concept. The idea that this particular amendment does amend one particular section of the Alachua County Charter. And at its heart, the charter is a document that allocates powers. It provides the county with the power to preempt. And in this section, the county is using that amendment process to exercise its power to preempt municipal governance in this area. Now, to Mr. Theriak's
Yeah, but
point.
does the term amendment really capture what's really going on? An amendment would be changing 4 to 6 or 4 to 8. You know, the term of office would be, and we're changing it from 4 years to 6 years. Instead of submitting documents to the clerk, you'll submit it to, I don't know, the chair of the commission, something like that. That, to me, strikes me as, that sounds like an amendment. A reorientation of powers, or taking power away from a municipality and putting it in the hands of a county. Yeah, it's one amendment, but it's pretty significant, lengthy. That sounds more like a revision. And I guess my question was, would it have made a difference in the summary to identify it as a revision, that this is more comprehensive? We're now giving the county more preemption power at the expense of the municipalities, as opposed to a voter trying to parse through the description of, well, what does it mean to be exclusive and that kind of thing.
If you're looking at the ballot summary and the ballot title, the concept of providing fair notice to the voters, an amendment, I think, is a more commonly understood term for you are changing a document. As you mentioned with the constitutional amendments, it's something that a voter would know. They would understand that this is changing the text of the document itself. The distinction between a revision and amendment, I think, would also open it up to a question of, does a voter have fair notice of what that does? That a revision is perhaps a more global change to the text versus something like an amendment. And particularly when you're looking at just one section as we are here, I think amendment captures that concept that in this particular section, we are amending it. Now, charters themselves, as I mentioned, are a document that lays out those powers and gives the power to preempt. And any voter who informs themselves or educates themselves as to the ballot question in front of them would see that this is reallocating or shifting those powers from a regulatory standpoint only within that county growth management area.
Which part of the summary actually highlights that for the voter, that this is a significant shift in power from the municipality to the county? I mean, the power to preempt in a charter county is significant. I mean, it's captured in the Florida Constitution, and you're supposed to specify that in the charter. as to which is going to supersede the other. And it was one way in the charter, and now it's being changed for one purpose. Where in the summary does that highlight that
think-
significant change for the voter?
Yes, sir. There are three portions of the ballot summary that I believe touch on that. There is the outset where it says effective countywide. It's notifying individuals that while you may live in a city, this is something that will impact residents of Alachua County on a countywide basis. It also addresses the idea of exclusively governing land development in that growth management area, and that the county, the implementing ordinances shall prevail over conflicting municipal ordinances. On three separate occasions, that language, and once again, we are confined to 20 or 75 words in that language, notifies voters that there is a shift from what would otherwise be a municipal authority to something that is a county authority.
Well, which part tells them that there's a shift? Like,
The-
where's the part that says, hey, this is the way it was, and we're now shifting it? Like, where is it that they're informed that the municipalities did have this power, and now they're not?
The area that discusses the prevailing over conflicting municipal ordinances would put a voter on notice that these same land development regulations, these same comprehensive plan, the growth management exists in municipalities and in counties, and there will be a conflict. And in the event of that conflict, the county's charter or the county's implementing ordinances will be the ones that prevail.
Can I ask you about the area? There's no mention of a map or reference to, map on file with the clerk or anything like that. There's no mention of how extensive this is in terms of acres or square miles. It's apparently pretty big from, what you see in the briefs. Did that need to be in there? Should it have been in there?
I think there's always the question of woulda, coulda, shoulda, should it have been something that is advised? But I think the appellants mentioned the Volusia County case in which there was an urban growth boundary that was on the charter, and the court said, well, that map didn't exist at the time. So if the map didn't exist, no voter had the opportunity to inform themselves as to what that map was going to be. The distinction here is that the map existed. It was created during public meetings by the Charter Review Commission. It was adopted by the Board of County Commissioners at a public meeting, and the map was specifically on file with the clerk of the Board of County Commissioners. So it was something that when you look at the Miami Heat case, the idea that a voter has some obligation or responsibility to educate themselves and inform themselves before they go into the ballot box, they would have the opportunity to actually see something. And that's the key distinction from the Volusia County case, that no matter how educated or eager a voter was to learn about that ballot measure, they were never going to know what the map looked like.
Are there instances where maps have been put on the ballot with the summary?
I cannot think of any off the top of my head. But as I mentioned, it's a question of what does the language say when we read it as written? There's always the question of, was it as artful as it could be? Is there another way to write it? But when we look at it and we think about the context of what existed at the time that a voter would be preparing to vote, they had every opportunity to either comment on the map prior to its adoption or review the map prior to voting itself.
The charter before the revision provided that municipality, conflicts between a municipal ordinance and a county ordinance and municipal ordinance prevail, right?
Yes.
So going back to my original question, so if I just read the summary, just as, just a regular voter, I might not know that the status quo is that the municipality ordinance prevails. So when I read this and say, oh, well, and, the county ordinance is going to prevail over municipal ordinance, I may not be aware that that is a fundamental change in the charter, which is originally provided for in the Constitution, that this is a critical question that the charter is supposed to address.
When you go back to the notion that that voter does have the opportunity to inform themselves prior to the vote, they have every opportunity to look at the charter as it exists today and not rely solely on those 75 words. When you have that opportunity, you do have the option to see that it says municipal ordinances will prevail for land use planning is the specific allocation there. Because once again, under the Constitution and under Chapter 163 of Florida statutes, those powers have been allocated previously to the municipalities, and were now being changed and shifted to be county authority.
What do you think of the idea of this statutory provision being applied one way to local referenda and the way that the Supreme Court applies it to Florida constitutional amendments?
I think the idea of applying it to the way that the Florida Supreme Court applies it to constitutional amendments, it provides some uniformity for voters and for local governments to have another body of case law showing what exactly they need to satisfy. In this case, the idea of the chief purpose, not doing so with misleading language, the word count. I think that creates that uniformity, and in this situation allows us to look at this language not just in the context of other local referenda, but also the constitutional provisions as well.
I mean, the reason I ask that is that what ostensibly started as just a procedural mechanism for convenience, because you many times can't put an entire charter amendment on a ballot. So say you have a summary as a placeholder, so they know what they're voting on. Just, okay, I know I'm voting on this charter amendment under, Measure 1 and a different one under Measure 2. But beside that, to turn that into a public right or something more substantive so that, a court is stuck invalidating what has already been a voter-approved revision, or an amendment.
And I certainly
It has more significance at the constitutional level. You revise the Constitution that has statewide impact, and then you have courts that are enforcing it. I mean, it's a bigger deal. Not to take anything away from a local charter, but the charter is obviously more local. There's different considerations and different uses of a charter than there is at the constitutional level. So I'm just wondering how it is that we're taking sort of big initiative process, where, their consequences are high and statewide and much more permanent, and applying it to as a substantive right or a substantive public right at the local level. So that we're sitting here then trying to read a summary and trying to parse through, I don't know, is it reasonable notice for growth management? I mean, how is that a question of law? That's a hard call to make sometimes. Anyway, that's why I'm asking.
Yes, sir. And I think the line of cases that Mr. Theriak alluded to, we're working with what we do have, as far as the constitutional amendments and how they apply to local referenda. Ultimately, I agree with the notion that this court is being asked to overturn the will of the voters. That is a matter of great public import. And I think when you look at those cases, that's where you see the standard that we're not going to strike language unless it's clearly and conclusively defective. And so from a local referenda perspective, we are operating under those same constraints as far as the word limits go, as far as what needs to be conveyed. But we do also have that same level of public importance that, not quite the same when you're dealing with constitutional rights, but the charter does act as essentially the constitution of the county, in the sense that it does allocate those powers to either municipalities or counties. So
I mean, maybe the statutory provision, the 75 words, maybe that's the legislature's effort at putting a substantive limit on expecting the voters to do too much in one proposal. If you can't summarize it in 75 words, maybe you're trying to do too much. And so, here you have multi-layered, putting an entire growth management policy into the charter and trying to summarize it in 75 words. Should that enter the equation that, just looking at this summary can't possibly capture everything that, or even substantively summarize everything that you're doing in this complicated substantive charter change?
Yes, sir, and I think there is a balance between the 75-word limitation and the notion that the voter does have to inform themselves. There are cases that state that it is not the job of the ballot summary to educate the voter. It is to provide fair notice, not of every ramification specifically, but just of the chief purpose, so that the voter can look at that and say, I'm going to go do more research. I want to understand what this does, but I know that at its base level, what this is intended to do. And appellants have argued that the chief purpose is some effort to thwart annexation. And I think when you look not just at the text, but even the implication of it, it's just not there. The chief purpose, if you go line by line, which I won't bore everyone with, but is to establish this county growth management area. If that was the end of the discussion, that would not be enough to put someone on notice. But it then goes on to elaborate and to explain that within that area, whether inside or outside municipal boundaries, the county's comprehensive plan and land development regulations will exclusively govern land development applications. So it is saying the chief purpose is this land development regulation, comprehensive planning within this area. And that is the end of it. It does not create a new process by which annexations must be reviewed. It does not create new standards under Chapter 171, the annexation statute, by which annexations have to be reviewed. It just says if you're going to develop land in the county's growth management area, whether you are inside a municipality or not, you will have to comply with those county policies. And there are a number of reasons why an individual property owner may wish to annex. It could be for more efficient municipal services or a millage rate. Annexation is not the sole reason. So changing, growth management is not the sole reason somebody might annex into a municipality. So changing what policies apply does not change the overall statutory scheme of that.
The Supreme Court says 101-161, purpose means effect. Those seem to have different definitions to me. Should purpose mean, if we were writing on a blank slate, or if we were urging the Supreme Court to perhaps change their reading of this, should purpose mean effect?
I hesitate to put my own opinion in that, but I do believe that the effect is the overall end goal. What is it actually going to do, and not necessarily, to me, purpose implies a little more of the policy reasoning, what might have been intended.
It would seem to me that the purpose would be what the commission intended to do with it, and the effect, is what is happening now and what may be happening 10 or 20 years in the future. We don't even fully know the effect as of yet. It's only 5 years into the adoption of the amendment. So the effect could be good, bad, otherwise, but we don't know that yet.
Yes, sir. But the effect itself, the intended effect, was to apply the county's growth management policies in that area itself. Now, there may be ramifications on annexation. Someone might choose not to annex because what's the point? But that's not, ramifications themselves are kind of a peripheral issue. It's not something that the county would have an obligation to provide fair notice of, that in these 75 words, we're going to let you know that maybe you don't want to annex at some point. At no point in this language does it use the political rhetoric or emotional language of this is going to be better or more protective of anything. It just says whatever the county's growth management policies are at the time of that land development application, that is what will apply in this area itself. And as far as the idea of the purpose being more of a policy-oriented discussion, it's hard when you're dealing with something like a charter review commission that is a number of citizens and then moving over to a board of county commissioners, imputing whatever purpose one individual charter member might have had, charter review commission member might have had, or whatever purpose one individual commissioner may have had. So in that sense, you look at the language itself, and the language itself as written says that the chief purpose is to create this area and apply the county's land development regulations.
Chief purpose is singular, right, in the statute, and here it looks like you got 5 purposes.
Well, the idea is, the ultimate chief purpose is the county's comprehensive plan and land development regulations will exclusively govern land development in the area. That is the chief purpose.
Well, the chief purpose is to shift power from the municipalities to the county to control growth management, right?
In a sense, that is what this is doing. It is essentially anything that is done in a charter is going to be that shift in power, because that's what the charter exists for. But this is identifying what that shift actually does. And so when you read those two things together, it is that the county's comprehensive plan and land development regulations will apply in that area. And it creates that defined area that is the map showing which areas we are talking about, which areas this is limited to. As far as the other considerations that courts look at, you have the idea that the language is not misleading, and that could either be through expressly misleading language or omission, the idea of flying under false colors. When you look at this language, this is not the same as like the Save Our Everglades case, where it used that rhetorical language to play on the sympathies or proclivities of each individual voter to say, well, if you don't vote on this, the Everglades are going to be lost, something like that. It does not say this is for the benefit of the natural resources or.
And you
or the-
wouldn't put growth in that category, as opposed to saying that we're establishing a power management area. I think you both use the word power. This is in some sense about power. Here, it uses the term growth, and that's not problematic.
Growth management, I think, is a commonly understood term in Florida. If you go back to the 1985 legislation that really created a comprehensive planning policy in this state, it's commonly known as the Growth Management Act of 1985. In the county itself, voters would understand that the county's department that deals with these is the Growth Management Department. It's a term that in some context could be considered that, but in the context of Florida and Alachua County, I don't, that language just conveys exactly what it is. Thank you.
Thank you, Mr. Hanson.
Thank you. The county's argument regarding the creation of the area was necessary to make it clear that the county's regulations will apply in the area is circular. They already apply in the area. They did not need to create a growth management area to apply regs that already are in existence that apply to that area.
But the purpose here really is to make that perpetual, correct?
I didn't hear
It
you,
wasn't
sir.
perpetual, wasn't perpetual before this amendment passed. But now it will be, the county's word will be perpetual over all of this identified land
It will
into
be
the future.
It will be perpetual over any property that is annexed into a city. And to contend that the purpose was anything other than to take the power
Well,
away
it's
from
also
the cities.
perpetual as to all the other land. All the other green land on the map that will never be annexed into a city, it's perpetual there too.
Yes.
Yeah.
But it's also within the county's control to do whatever they want to do with that land. We're focusing in on what happens to the city's regulatory authority after the charter amendment passes. And to contend that somehow we need an area to apply regs that already apply is a chief purpose I would submit is not the chief purpose. The chief purpose was to strip away power. It was about who got to regulate when property is annexed into a city. Is it the county or is it the city? And there is absolutely nothing in the language, whether the title or the summary, that puts an average voter on notice that what's really happening here is we are stripping away power that cities have possessed for years. And we're taking that power and we're giving it to the county. And I
I mean,
just.
do they have to be that directive? I mean, do they have to kind of give the countervailing argument against the amendment in their ballot summary? That
No.
This is going to take all your power away and,
Not at all.
But we're going to save the alligators in the wetlands, so, we've got some balance.
But I think they have to mention it. I mean, they had words left over. They were below the 75. But somewhere in that summary, and we're not telling them how to write it, what we're saying is to comply with state law, the chief purpose is you are stripping powers away from the city.
And it's not good enough to say that this is going to exclusively govern land development, whether inside or outside municipal boundaries. That's not good enough because in your view, the average voter won't know that municipalities currently control land development in municipalities.
Exactly.
They don't know that.
There's nothing in that, the language that you just quoted, Your Honor, that an average voter, because, that means the city has the power now. It doesn't say that. So to me, that's one of the most fundamental flaws in the charter
I
amendment.
mean,
I would-
doesn't, though, the amended, right in the first line, shall be amended, that's changing, the status quo is not going to be the same if this passes, so doesn't that put the voter on notice that the charter, if this passes, shall be amended effective countywide?
And I agree that the first sentence says they're amending their charter, but there's nothing in any of the subsequent words that put an average voter on notice that cities are going to lose their regulatory power over annexed properties. It's simply silent. And we would submit that that is a significant fundamental change to the regulatory program regarding municipalities and annexations that should have been at a minimum mentioned in the summary, and it's not. And I would also note in footnote 2 of our reply brief, the concept that voters are supposed to do research is rebutted by 2 cases cited in footnote 2, including Smith versus American Airlines, quote, "The availability of public information about a proposed amendment cannot be a substitute for an accurate and informative ballot summary." And so the fact that a voter could have gone down to the clerk of court to look for a map that they don't know exists, I would submit it is not the test. The test is, did the summary put the average voter on notice? Were they informed that there was this fundamental shift? And they were not. And if there are no other questions, we ask that you reverse, this court reverse the circuit court and direct that final judgment be entered in favor of the cities. Thank you.
Thank you, Mr. Theriak. That is our only oral argument for today, so we are adjourned.
All rise.